Welcome to ThePrint. 6 years after the Supreme Court declared right to privacy as a fundamental right, India finally has a data protection law. The Digital Personal Data Protection Act received the President's assent and was notified in the Gazette last week. However, so far, the law has received a mixed reaction of sorts, with specific concerns being raised over the wide-ranging government exemptions, among other things. What does the law exactly say? What are the rights and duties that it provides? And what sort of exemptions does it look at? We'll answer all of these questions for you today in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court Advocate on Record Namit Saxena here with us to decode this new law, the newest law of the country for all of us. Thank you so much for joining us.
Thank you for having me. It is also a very auspicious tithi today.
Okay.
It's Adhik Mas Amavasya today. So may Baba bless all of us and show us the right path.
Thank you so much for joining, Namit. So before we actually decode the bill, as Apoorva pointed out, the debate over privacy began way back in 2017 after the Supreme Court delivered a very significant ruling in the Puttaswamy case, where it said that privacy is a part of fundamental right. So, of course, this is the background as far as this bill is concerned. But for our viewers, could you just reflect a little bit on what the case was about and how this journey has, just trace the journey from 2017 onwards till this bill was finally notified?
Even prior to 2017, in 2012, there was Justice AP Shah, who was, authorized to look into it, for the first time, because that was the advent of social media, advent of, apps, etc., advent of internet technology, etc. So Justice AP Shah looked at it for the first time in 2012 when he was the Law Commission chairperson. In 2017, the importance is that in Puttaswamy, the thrust of the matter was that in case when the framers of the Constitution decided and deliberated upon right to privacy to be included in the Part 3 of the Constitution, and they took a conscious decision that we will not have this as a fundamental right, even then the Supreme Court and the judiciary can say no, this is part of the fundamental rights of the Constitution, Part 3.
Yeah.
And the core argument of that was that there were two judgments, MP Sharma and Khadak Singh, that those two judgments say that right to privacy is not a constitutionally guaranteed fundamental right, which the Supreme Court 9-judge bench said, no, it is incorrect. We are overruling them. And right to privacy is a fundamental right to be read into Article 20 of the Constitution, 1. Second, it is to be guaranteed by the state. What they also said, in their judgment was that, that the Parliament should frame a law and look into what privacy actually, means to suit the law and order requirement in the society, considering whatever has been happening globally. Now, this after 2017, there was a Justice B.N. Shri Krishna committee. Then the 9-judge bench matter went to a 5-judge bench matter where the main Aadhaar judgment happened. And then there were deliberations which were taken by the central government, and bills were tabled in the parliament also. They were taken back, sent to the standing committees, etc. Now, what has finally culminated into, we have this set of 40 odd sections in the form of, then the earlier versions were different. Now, what we have is digital Data Protection Act, DPDP Act, Digital Personal Data Protection Act. Earlier versions were only data. Now they have qualified it with digital data and digital personal data.
Okay.
So this law, what we have now today, passed by both the houses and the president, is in form of, if I may call it, an oversimplification of the entire process, in which they have, written down certain provisions. This is sort of, the skeleton. Rules, there are 25 sections which require rules to be framed. So those rules are yet to be framed. And in fact, if I may say, that there is a Mahavakya which goes like, Shakti bina Shiv bhi Shav hai. So, this is sort of the Shiv, but without the rules in the form of that Shakti, it is more or less redundant until those rules actually come into picture.
Right. So what was the reason for the government to withdraw the earlier bills? Were they incomplete, or was it that the government was unable to put in all the features in that bill? Why did they have to withdraw, I think roughly around 4 or 5 bills before they could actually bring in a final one?
So perhaps in their wisdom, they perhaps decided that these laws are not suitable, or these bills do not properly cover the entire arena of data privacy or informational privacy. So they perhaps deemed it fit to that we should not, we should concise it to a short version of, rather than 120 odd sections, have a 40 odd sections, act. And then let's see how it goes, because, a lot of times, and these are very changing times, the law, the technology is constantly changing. So perhaps they want to experiment with this then let's see, and then subsequently how it functions, we'll frame and alter rules accordingly. This is what perhaps the idea may be.
So let's start with what Apoorva said, that there is severe criticism to the bill, probably because of the several exemptions that have been given to the central government. Can you just explain that for our viewers? Let us start with, let's go point by point, because I'm sure there is something even for our viewers in the sense that there's something to be offered to the citizens also. There is something for the data fiduciaries that are the intermediaries. But government, many people who have criticized the bill have actually said that government has given itself immense powers under this law. So what is the meaning of this statement?
See, I would say that they are not entirely wrong in saying that the central government has, empowered itself through this law, which is in a sense right, that the central government has actually done it. But for that, we'll have to go through certain definitions first as to, we'll have to see who's the data principal. So a data principal primarily is an individual who, is supposed to give his or her personal data. And this is very unique law. I'll just, I'm just taking other road.
Please digress.
What they've done is, they've used, and this is unique in that sense, they've used the expression her and she everywhere instead of him and, so it is sort of, yes, it is sort of that the pronouns which they've used are she and her. And they've defined it also to include male acronyms, etc.
Okay.
So what this law primarily does is the data principal is supposed to be an individual who, shares her personal data through data fiduciaries or through data processors for processing of data, storage of data, transmission of data, etc. This is data principal, who is one of the key players in the data privacy law.
So if I want to describe a data principal, could be
Yes.
Anybody.
Yes. Yes.
Right?
We are data principal for the purposes of this law.
And data fiduciary could be even the apps.
Yes.
We kind of share our information or, okay.
Yes. So unlike data principal, who's supposed to be an individual and not an artificial person, a company will not be a data principal for the purpose of this act. Data fiduciary can be a bank, for example, who takes data, or a mobile application which takes your data. And, for example, an application like Practo, where you book medical treatment or medical checkup, etc., that is a data fiduciary for the purpose of this law, which includes the definition of a person. So that what they've done is they've given a means definition, that this means this means this, and not an includes definition. Includes definition is supposed to be non-exhaustive in nature.
Right.
Then another important player is a definition which they have given as a consent manager. A consent manager is supposed to be a single point of contact for the data principal, and it is not completely vocal about can there be two consent managers for a data principal, etc. So, and who will, sort of there is a breach, that consent manager is accountable to the data principal. What are the qualifications of becoming a consent manager? We don't know yet. Rules are supposed to be framed in that regard. Similarly, an important definition.
Just
Yes.
briefly, so consent manager, is this an independent person, or is this somebody who's associated with the data fiduciary?
No, it is supposed to be an independent person.
Right. Okay.
So it is not supposed to be having some sort of a posting in the data fiduciary that this is the designated consent manager for us. No, it's not like that. There can be multiple consent managers. Or multiple different entities, etc. Another important definition is that of a personal data breach. So personal data breach, for example, they have defined what is a data. They have defined what is a breach. And what is personal data? So that data is further qualified, as I said in the beginning also, that personal data breach also they have defined. What is a personal data, and what are the implications of breaching your personal data as such? That also they have defined. Another set of important definition is they have defined who is a significant data fiduciary. So data fiduciary is further, given a class of being a significant data fiduciary, where the central government has the power. And I'll, come to how central government has, sort of empowered itself, that the central government can classify a data fiduciary into a significant data fiduciary and exempt it from everything.
Okay, so that power is with the government, with the central government.
With the central government. And what they can also do is they can, choose a particular data fiduciary or a class of data fiduciaries. For example, the central government could tomorrow say all banks or all NBFCs or all financial institutions, they are exempt from, complying this law.
Is there any criteria on the basis of which this
Not
is done?
in the act.
And is there a requirement for reasoned orders to be passed when that declaration is being made?
That is central government's power to do it.
Okay.
Also, what is important is to note the territorial, sort of application of this act. So it is territorial as well as extraterritorial. For example, somebody, or a data fiduciary breaches data privacy in the country, in the territory of the country, that data fiduciary is liable. And also if it transmits it to, a country abroad,
Right.
extraterritorial, where it is not supposed to do it by a notification of the central government, then also it is supposed to be in breach of this law.
Okay.
If there is no notification by the central government and it transmits, certain data to a particular entity in a particular country, then it is well within the ambit of this law.
Okay.
Right.
If there is a notification, that there has to be an express bar. So we have to read it in form of a positive covenant that there has to be an express bar. Similarly, when we discuss privacy, for example, particularly informational privacy, the application of this act, that is why it is unique and not as rigid as what we have in GDPR, etc. And the criticism that that we have to assume it to be an ideal law. See, the statement of objects and reasons of this act itself say that this is an act for processing of digital personal data in a manner that recognizes both the rights of individuals to protect their personal data and the need to process such personal data for lawful purposes. Okay. So it is both, one, individual centric, second, central government centric. So this criticism is valid. The central government has empowered itself, but this is what they wanted to do. This is what they've said, that we are empowering you, one, as an individual, second, ourselves, as being the ruling establishment of the country. So that is what, the statement of objects and reasons of the country, of the act is, and this is what they've primarily done.
So you've mentioned this very interesting point, lawful purposes.
Yes.
Have they defined lawful?
The lawful purposes is again...
Okay, that is again very...
Perhaps rules.
Since you mentioned GDPR, just briefly for our viewers, if you could tell them what the usual practice is across the world about balance of interests of an individual and the government.
See, I'll give you one good example.
Okay.
What is the difference between GDPR is General Data Protection Rights, which is supposed to be the strictest of all data or information privacy sort of rights. Now, this is a unique law because in section 15 of this law, what they've done is they've imposed certain sanctions in form of duties upon the data principals.
Right. So for citizens.
For citizens, for us, for you and me and Bhadra.
And what are these duties?
Now, for example, these duties include, I'll tell you, that they broadly, what do they include? But there is one particular section 15 clause C which requires deliberation. What section 15 says is a data principal shall perform the following duties, and clause C of this is to ensure not to suppress any material information while providing her personal data for any document, unique identifier, proof of identity, or proof of address issued by the state or any of its instrumentalities. And in case you don't follow this, there is a schedule appended to this, in which at serial number 5, there is a penalty.
And what is the penalty?
That penalty is rupees 10,000, but that 10,000 would be per breach.
Right. Per breach. So if we refuse to give our data for these purposes, then you could be liable.
Yes. So this is something which is absent in GDPR.
Right.
And all other, primary data privacy laws as well. They don't cast a sanction upon somebody who is supposed to be protected by that very law. So this very law is supposed to be individual centric and protect, our privacy rights. Yeah. But this very law gives the right to the central government to sort of bully us or to sort of say that, that no, in case you don't do this, although this is supposed to protect you, but no, we'll penalize you.
You need to reveal everything about yourself.
Yes. Okay. And interestingly, that is what, is, furthermore this thing. For example, they have section 17. And 17 clause 3 says the central government may, having regard to the volume and nature of personal data processed, although volume, what volume, what nature is all, in the Shakti, as we say, the rules, notify certain data fiduciaries or class of data fiduciaries, including startups. Okay. So, yes, and they have defined startups as well. As data fiduciaries to whom the provisions of section 5, 8 and 11, 10 and 11 will not apply.
Okay.
So they will say that these set of data fiduciaries, these entire, laws, the provisions of these laws are not going to apply.
So the protections under the law,
they can take away at any point of time. And further, if you'll see, there is section 35 and 36 of this. 35 says no suit, prosecution or other legal proceedings shall lie against the central government or any employee thereof. Anything which is done or intended to be done in good faith under the provisions of Act. So there is a good faith protection. Central government could tomorrow say, no, we did this for your protection and in good faith. So we are immune from any sort of, legal action or any sort of that. You can't claim any damages against us as well. And then Section 36 takes it further, and if I may call it, prone to oppression. Central government may, for the purpose of this act, require the board and any data fiduciary or intermediary to furnish such information as it may call for.
Okay.
So any information that the central government wants at any point of time, and there are no rules to be made in this also. They can call upon any data fiduciary and say, no, you have to give this information to us.
So which means the act actually empowers the central government to seek data not only from the data fiduciaries, but directly from the individuals also. That is the data principles?
No. So data principles, no, this is only for data fiduciary. Data principle will go to the data fiduciary. Central government is generally not, because you have to understand, central government can also be data fiduciary.
Okay.
For example, nationalized banks.
Yes.
PSUs.
Yes.
For example, somebody applies for a petrol pump license with IOCL.
Right.
IOCL will call for some N number of NOCs and N number of information about the data principle, etc. Now, that is a state agency. That is why the expression is state agency of instrumentalities.
Right.
Central government acts as data fiduciaries at multiple times.
Right.
And will process that information itself. So this is sort of, we are in a loop.
Yeah.
So it can also ask for information from data fiduciaries,
Yes.
and they have to provide.
They have to.
And what if they refuse? Is there a penalty for them?
There is a penalty for them, and that those penalties run into crores.
Is that sorry?
Karen.
So there is a litany of litigations also going on in this point, is it? And does this settle that point? Whether
No. So what this law primarily says is that there is no civil suit which is going to be there.
Right.
Once they constitute the board, what they're doing is they're constituting a Data Protection Board of India, DPB, we may call it. Now, all those qualifications, who will be the chairperson, who will be the member, etc., is not there. They have said that the tenure would be 2 years. Rest everything they are yet to decide, and certain qualifications, technical expertise, field of law, etc. are there. But primarily, they haven't said who is going to be the chairperson, who are going to be the members. Now, whatever happens, no civil court will have any jurisdiction.
Okay.
Anything happens, you go to the DPB. Now, one of the major criticisms of the law is that who appoints these DPB members or the chairperson? It is the central government. So it's like you go to a bully. The bully sort of bullies you. And to complain against the bully, you go to somebody appointed by the same bully. So this is one of the major criticisms of this law, that there has to be some independence. And this is where they go back to Madras Bar Association, Roja Mathias, etc. That, for example, we have tribunals. For example, we have NCLT, NGT, etc. Now, in the appointing board of the selection committee of these tribunals, there is some sort of independence because judiciary is involved somewhere. Chief Justice is there, or a designate of the Chief Justice is there. Here, that those rules are not yet there. So in case there is, from a bully to a bully by the bully is sort of the arrangement which we have right now.
So Namit, I want to understand that as a citizen, of course, I am sharing my data with the data fiduciary. And in case there is a breach of that data, do I have any rights against that particular data fiduciary or not?
Yes, you have.
Now, if a similar situation arises when a government breaches my data, what rights do I have? So if you can just explain the two situations and...
So there are 2-3 sort of variations of it. One sort of variation is, for example, if the central government or an instrumentality of the central government is the data fiduciary itself in form of a PSU or a bank or, some state run something, some program, etc. And the central government, acting as data fiduciary, breaches your data or data gets leaked, you will go to the DPB.
Okay.
Against the central government also in form of the data fiduciary, whichever is there. Now, they can be, joint ventures where the central government in its capacity of being the ruling establishment of the country or the state government of a particular state is in partnership with a private player who is supposed to be the data fiduciary. And there some data gets leaked. There this law primarily is silent. But my understanding goes that you can, go against both.
Right.
You can claim damages from both. You can say that there is a breach. And in case the central government is sort of the supervising agency only of a particular data fiduciary who acts as an intermediary, for example, a private player, completely private player, then you will not go against central government. in case there is some data breach. You'll go against that data fiduciary itself, that that this is what you are supposed to be doing under the law, and what the private players are supposed to do. There are two more things which before I skip, that there is a data audit.
Mm-hmm. Oh, so now you'll have a data audit.
Yes,
Okay.
you have to keep data auditors, and you have to do data audit, and you have to also sort of do data impact assessment. Personal data impact assessment also private players are required to do. How they will do it, in what form they have to store the data, what is the impact assessment criteria they have to follow, this is all in the Shakti again.
But these obligations are just for private players.
These are for data fiduciaries.
Data fiduciaries, and that could be a government.
In certain cases, the government or the instrumentalities of the state as well.
But in a situation where the government, say, like we mentioned, could ask the data fiduciary for data, do those obligations then apply to the government as well?
Yes, they do.
Right.
In case the government is in some form, active as data fiduciary, then all the requirements, because the definition says data fiduciary, so it will apply to them also.
So does the law provide for any redressal mechanism as far as the data fiduciaries are concerned? Suppose the government seeks any data from them and the fiduciary does not want to share it. Does it have an option to go somewhere before a tribunal, before a board, to kind of challenge that demand made by the government?
You'll have to go to DPP.
That's it, the board.
DPP.
Okay.
DPP is supposed to be, the umbrella under which...
But can it do it under the Act? Does the Act permit it to do it?
It can, because the expressions are very loosely worded.
Okay.
So under those expressions, you can. As a matter of a statutory right, you can go to DPP, that this is what the central government is asking. But in our view, this is supposed to have major repercussion on, data information, whatever we have of, a certain set of people. So we want you to adjudicate upon it.
Right.
And in such a situation, can a data principal go? Suppose a data principal gets to know or gathers information about, this kind of a engagement going on between the government or the data fiduciary, where the data fiduciary refuses to share a data. Can a data principal go in such a situation or not?
It can also go to the DPB, and data principal can go against the central government as well as data fiduciary both. That in such a case where the central government is asking something and data fiduciaries, perhaps there may be cases where data fiduciary is also willing to give.
Okay.
That we are under a bound, under bounden duty to give under the law. We want to also give, but the data principal says this is my data. I don't want to give, because there are provisions that you can get your data erased also, reviewed, erased, etc. These are all provisions there to a certain extent. You can withdraw your consent also.
Can you just share that? Because I wanted to ask you a question, whether it is mandatory for data principals to share their data.
No.
And if they do, can they seek erasure of it in future?
It is mandatory in two cases, where it is for under some guidelines, legal guidelines, or it is for some lawful purpose, etc. Then they're required to give. Or in case they have voluntarily given something, they have already uploaded. For example, somebody writes a blog. And on that blog, all the personal data is already available, including when did he pass from law school, or when did she, attend some LLM somewhere, etc. All these details are there, then they're already there. But the data principal can say that this is the extent to which I want to give my data.
Okay.
And this is the extent to which my data is required for this specified purpose. Beyond this, I will say no.
Okay.
And once that specified purpose is over, the data principal is empowered to now say to the data fiduciary, now either erase my data, return my data, and then you will never use my data also against my consent or without my consent. So all these powers the data principals have.
Does the law address right to be forgotten as well?
So right to be forgotten in certain, the expression forgotten is not there,
right,
but the expression erasure is there.
Okay.
So, for example, we have, and this was discussed in Puttaswamy judgment also. There's a 1995 judgment which dealt with that somebody's divorce matter was uploaded on a particular website.
Right.
And they said, I don't want to be there anymore, because anytime I apply for a job, this is something which pops up immediately under the SEO of Google. And therefore, please, direct them to remove it. So that was actually directed. So right to be forgotten, in a sense, is judicially described under the jurisprudence we have.
Right.
But this law primarily does not talk about, as such, directly right to be forgotten. But it talks about it, right to have something erased from internet's memory.
Right.
Or get it down SEO as we understand.
So, Namit, this law has also brought about amendments in certain laws, and one of them being the Right to Information Act. Can you just briefly talk about it also, because even that is under, severe criticism?
Yes. So what it primarily does is it amends 3 laws. One is the Telecom Regulatory Authority of India Act, because appeals from DPB will go to TDSAT.
Right.
Okay.
So they've amended that law because appeals have to go to TDSAT is one. Second, what they've done is they've amended IT Act. 43A is gone. And in section 80A, I think they have said that, apart from Patents Act, DPDP Act will also be inserted for the purpose of that act. And then third, they've, sort of amended section 81J of the RTI Act. Now, 81J, if you remember, 81J talked about, that the exemptions.
Yeah.
That these are the exemptions under which, an information can be denied to, or these are exempt from the RTI Act. Now, 81J had this expression larger public interest. That in larger public interest, the central government or, the whatever the agency is, can say, no, we'll not give this information to you. That is gone now.
Right.
What they've substituted it with is that information, which is in form of personal information, which in my view is even broader, subject to, certain things, that all this personal information is also gone. It is exempt. So nobody can, as a matter of right, claim that this is an information of a particular data principle, which falls in the category of personal information. As a matter of right, I'm asking for it. The agencies can say, no, this is now exempt. We'll not give it to you. So these are the primarily, the 3 laws which they have amended. But I must highlight one more thing, which I don't want to miss, which is Section 7, Clause E. Section 7 is in form of that a data fiduciary may process personal data of a data principal for any of the following uses. Now, Clause E says, this is very interesting. It says, for compliance with any judgment or decree of order issued under any law for the time being in force in India and any judgment order, contractual or civil in nature. Then Clause G says, for taking measures to provide medical treatment or health services to any individual during epidemic, outbreak of disease and any threat to public health, which is because of the COVID thing. Now, Clause H says, for taking measures to ensure safety of or provide assistance or services to any individual during any disaster or any breakdown of public order. Now, this expression breakdown of public order, subject to my limits of comprehension, is extremely broad. What is a breakdown? What is order? What is public order? And what is a breakdown of public order is, very extremely whimsical of the, the ruling establishment, which at times in any, form of government acts as bully. So this can be used by them to again, extract information against the wishes of data principals or against the wishes of data fiduciaries or against, wishes of, whosoever is further involved as well. So this again is very broad.
So in your opinion, does this law actually strike the right kind of balance, which was, propounded in the Puttaswamy judgment when it comes to privacy rights? So does it really strike a balance between an individual's right and the government powers?
So I would say that it's sort of, because this is a good start, I would say. There is at least a start, if I may say so. But this is sort of tilted towards the central government.
Okay.
Privacy is supposed to be individual centric. It is okay that the statement of objects and reasons, as we just, read out, that it is, supposed to be a mid path between individual rights and, the rights of the central government to, to have, sort of certain things. But this is inclined towards central government.
Right.
Which is one of the major criticisms of this law. That, something which is supposed to be individual centric and something which is supposed to protect the data principle, you impose a penalty, upon him that, in case you don't furnish the information, then, that we are going to penalize you. So this sort of, grabs, the real essence of the privacy judgment.
Right.
Because the privacy judgment is very clear. It has to be individual centric. You tilt it, towards you a little, it is okay. But you change the complete dimension of the axis of it and, make that, so that is something which requires, and I think in rules, they will perhaps dilute it down or ease it down. That is why it is supposed to be. That is why, Bina Shakti Shiv Bishavan.
On that note, we've reached the end of this episode. In this episode, we spoke about what the Digital Personal Data Protection Act says and how it makes India finally one of the democracies that has a regulatory framework for privacy. However, as Namit says, the law so far seems inclined towards the powers of the central government instead of being individual-centric. However, we do have to wait to see what the rules that are framed under the law says. Till then, thank you so much for watching. Do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.